And I now call upon the Honorable Attorney General and Minister for Justice, General Siromi Turaga, to move his motion.
Mr. Speaker, sir, before I deal with the bill, with your indulgence, with heavy heart, I wish to formally announce the unfortunate passing away of the Chief Justice, Justice Kamal Kumar. His Lordship passed away at the care of doctors at the Osini Hospital in Suva. Honorable Justice Kamal Kumar was born on the 18th of December, 1963, passed away 21st of November, 2023. He had 6 brothers and 3 sisters, attended Andhra Primary School, Lautoka, and his secondary education was at Pandit Vishnudao Memorial in Saweni, Lautoka. He was married to Sunita Devi, and he has 2 sons. His eldest son, Chris Neil, resides in Brisbane, and the younger Shiv Neil resides with Kamal in Suva. Justice Kamal, in January 1884, joined the law firm of Stuart Reid & Co. as a junior clerk until 1988, when the law firm of Stuart Reid & Co. was wound up as a result of the military coup of 1987. He joined ANZ Bank, Singatoka branch in 1988. He then joined Young & Associates, a clerk, in 1992. In 1994, he decided to study law and enrolled in Queensland University of Technology in Brisbane. After completing his Bachelor of Law degree in March 2000, he was admitted as a barrister and solicitor of the Supreme Court of Australia and Fiji, and returned for the employment with Young & Associates as a solicitor. In May 2012, he was appointed as a pushing judge of the High Court of Fiji. He was subsequently appointed as acting Chief Justice in 2019 and was confirmed as Chief Justice of Fiji. Throughout his adult life, he was known to be a charitable and financially assisted several iTaukei Indian students with their education. He had a quiet demeanor and never sought acknowledgement for his social services to the community. The government of the day, the coalition government, the legal fraternity, and I'm sure the previous governments appreciate his service to the people of Fiji. The coalition government would like to pay tribute and sympathy to his family. Thank you, Mr. Speaker, sir. Mr. Speaker, pursuant to the resolution of Parliament, Tuesday, 21st November 23, I move that the iTaukei Affairs Amendment Bill 2023 be debated, voted upon, and be passed.
Is there a seconder?
Mr. Speaker, Sahib, second the motion. Thank you.
I now call on the Honorable Attorney General to speak on his motion.
Mr. Speaker, sir, I rise to contribute to the debate of the iTaukei Affairs Amendment Bill 2023, which was tabled in Parliament on Tuesday, 21st of November, 2023. As highlighted before the honourable members of this August House on Tuesday, the bill essentially seeks to amend the iTaukei Affairs Act of 1944 to reinstate the Great Council of Chiefs, or commonly said GCC, otherwise referred to as the Bose Lebu Waka Turaga. At its initial inception in 1875, The GCC, comprising of Fijian chiefs, was established as an advisory body by the British colonial government, who had recognized the valuable insight that these traditional leaders could provide on indigenous affairs, and that their participation in the administration would result in a more effective governance of their respective people. The GCC considered matters relating to native provincial regulation, taxes, laws, and punishments, engaging in key discussions with the colonial government and making resolutions along the way. The active participation of the Council culminated in the creation of laws such as the Native Lands Ordinance in 1881, the Fijian Affairs Ordinance in 1944, and the development of a traditional system of land, tenure, and the Matangali Land Unit, Mr. Speaker, so it also includes the establishment of schools such as the Bulinitu, which is known as Queen Victoria School today, and Andi Lakombau School. The Fijian Affairs Ordinance of 1944, now referred to as the iTaukei Affairs Act of 1944, is one of the core legislation pertaining to the indigenous people of Fiji, and Section 3 of this Act provided for the Great Council of Chiefs, which was to make recommendations and proposals for the benefit of the iTaukei people, and to consider questions relating to the good government and well-being of the iTaukei people. In early 2006, there were trainings conducted for village headmen, Matangali leaders, and clan leaders under a pilot project endorsed by the GCC. Before the fateful day, 6th of December, coup took place the same year, which ultimately saw the suspension of the Council in 2007. The GCC was eventually removed altogether in 2012, some 5 years later. Mr. Speaker, so, not by phasing out due to impracticality or lack of purpose for it, nor by collective desire of the population to do away with it, but it was abrogated under authoritarian rule through the iTaukei Affairs Amendment Decree 2012, which deleted Section 3 from the provisions of the iTaukei Affairs Act 1944 in the period prior to the return of democratic governance in our nation. Because the people of Fiji were not consulted by the regime at the time of the removal of the GCC. But as regarding its reinstatement, this time around, under the coalition government, there was a review committee set up, a wide consultations held, which have yielded positive responses, as the Honorable Minister of iTaukei Affairs had shared his ministerial statement on Monday before the members of this August House. Publication for the Fiji Times of the 7th of August 2023, sharing the results from the Tibet Times poll, also found 64% of Fijians surveyed were in favor of reinstating the Bosele Vaktura, and 76% overall, when only the support and don't support responses were considered, without the undecided responses and responses refusing to answer. Mr. Speaker, sir, although we stand in Parliament today as the elected representative of the people, our leadership does not exist in a vacuum within our society. May I say that again? Our leadership in Fiji does not exist in a vacuum within our society. For over a century and to the present day, many men and women have stood up in their chiefly capacity to govern, represent, and advocate for the traditional Vanua, a role which was reflected in the former provisions of the Act that was removed. Mr. Speaker, so it's only befitting, with gods on our side, you are seated as a speaker to hear this very emotional, momentous occasion of a critical part of the iTaukei, the GCC. And not only for the iTaukei, it's for the entire people of Fiji, who call Fiji home. On the 14th of June 2023, His Excellency the President Ratuvilambe Katunibere informed the 111th session of the International Labour Conference in Geneva of Cabinet's decision for Fiji to adopt an official position of support for the United Nations Declaration on the Right of Indigenous People, or what is called UNDRIP. The establishment of the GC would provide crucial insight that is currently missing towards equitable governance and inclusive development at a time when statistics show a significant percentage of those living below the poverty line iTaukei. I also echo the statement made by the Honourable Minister Sakasi Toka in the media whilst visiting Rotuma earlier in March this year, that with respect to Rotuma, it is a more bottom-up approach would be taken in progressing projects on the island. It's not a two-man rule. It's not from the top, bottom. It's a bottom-up approach. It's one of consultation. And reiterate the commitment of this government in amplifying the mediums available for community dialogue. Early this year, work towards this end was progressed by the repeal of the Media Industry Development Act, which saw the return of a greater press freedom. And in terms of present bill, it is the reinstatement of the GCC would allow for a holistic approach towards solving the issues facing Indigenous people today and related matters. Mr. Speaker, sir, Opposition Member Honourable Usumati, in his statement on Monday, when referring to the GCC, being the body which looks after everything in relation to iTaukei, then stated, and again I quote, all these things are enshrined in the Constitution, unquote. Honourable Speaker, while the Constitution recognizes the iTaukei people, the ownership of iTaukei lands and culture, it does not comprehensively deal with all things relating to the iTaukei. And it is the facade of the mistake that the earlier government was hoodwinked by the former Attorney General, that everything is protected in the Constitution. If they have a good understanding of the law and the Constitution, you don't expect the nut and bolts of the law to be in the Constitution. You will find it in the Fijian Affairs Act. The restatement of the GC is not made unnecessary by the provisions of the Constitution. May I say this again? The reinstatement of the GCC is not made unnecessary by the provisions of the Constitutions, but rather the provisions of the Constitution make it necessary that the GCC be reinstated to effect the full realization of the rights and aspirations contained therein. The late Ratu Lala Skuna is famously attributed in saying that, quote, the title of chief is not an ornament, unquote. Much that is said about GCC is said from a historical perspective. So then is the role of the present day torchbearers. as shared by Honorable Basu on Monday, the GCC will emerge as a revitalized structure based on the strategic recommendations of the GCC Review Committee that are in line with international standards, which includes that the GCC be neutral and apolitical. Mr. Speaker, sir, there is also a potential for stewardship of a traditional Vanua to facilitate reconciliation and nation-building efforts, as demonstrated of the Wanimarab Nambal and Aruk Tundeketi, Protemi Mukepa, who made headlines in 2017 by declaring the descendants of dignitaries as part of belonging to the Vanua of Nodo and Rewa in a traditional ceremony that bestowed upon them the Buti, the Lubendra Naratu. The existence of the GCC does not necessitate the exclusion of other Fijians, a sentiment understood by the late J. Ram Reddy, who amongst other feats such as being a former leader of the opposition, briefly as an Attorney General, President of the Court of Appeal, was the first Indo-Fijian to be invited to a meeting of the Council on the 6th of June, 1997, at which he addressed the assembled chiefs saying, and I quote, that the members of this council are not just the chiefs of indigenous Fijians, but all of Fiji, unquote. With that said, Mr. Speaker, I now move on the pertinent features of the bill. Clause 1 of the bill provides for the short title and commencement. If passed by Parliament, the bill will come into force on a date or dates appointed by the Minister by Gazette, by notice in the Gazette. Clause 2 of the bill amends Section 2 of the Act by inserting the definition of council to mean the Great Council of Chiefs, and the definition of permanent secretary to mean permanent secretary responsible for iTaukei affairs. Clause 3 of the bill inserts Section 3 of the Act to provide for the constitution and primary function of the Council. Clause 4 of the bill amends Section 4, subsection 4 of the Act to require that iTaukei Affairs Board to refer to the GCC or the Bosile of Turanga any question relating to the iTaukei people that the Minister may submit to the Board. Clause 5 of the bill amends Section 5 of the Act to empower the Minister to make regulation in relation to the GCC. Clause 6 of the bill amends Section 11 of the Act to require the Minister to refer to the Board or the Council any proposed bill that is intended to be introduced in Parliament and which may appear to the Minister to affect in any important matter the rights and interests of iTaukei people. The Board or the Council, as the case may be, is then required to submit the proposed bill with a memorandum, which is to be used in the parliamentary debate process. Clause 7 of the bill consequently amends the iTaukei Trust Fund Act 2004, inter alia, to include reference to the Council. Conclusion, Mr. Speaker, sir. In the spirit of true democratic exercise, we have set out transparency. We have set out transparently the motivations and, in fact, the necessity for the re-establishment of the GCC within the codified ambit of law, and anticipate healthy debate and contributions from the opposition on the bill that has been presented before this House. This bill does not introduce a new entity, but brings back a council that existed and functioned practically before, and which is best suited to give recommendations and proposals for the benefit, well-being, and good governance of indigenous iTaukei and Rotuman people in light of the cultural dynamics, structures which pervade this nation and shape the reality. Accordingly, Mr. Speaker, sir, I commend this bill to Parliament.
Thank you. Remember, and then we'll alternate to the Honorable Minister of Fiji and Itaukei Affairs.